This is Chapter 12, Part 2, Field Interviews, Arrests, and Jail Searches. Chapter 12, Part 2. We are on slide 11. Standards for temporary detention. A Terry stop. Police with articulable suspicion of crime may detain a suspect and question them briefly. Right to detain, they need a reasonable suspicion of a crime, and it can't be mere suspicion, but reasonable suspicion. That might be a bulletin read in lineup of, and someone maybe fits the description. Look at page 356. So, standard for temporary detention. The police may temporarily detain someone for questioning if there are specific articulable facts that would lead a reasonable police officer to believe that the criminal activity is occurring. That's Terry versus Ohio. The right to detain. The standard to detain someone for a field interview is frequently called reasonable suspicion. It differs from the standard for making an arrest in several ways. Reasonable suspicion does not require as much evidence of wrongdoing as needed to make an arrest. For a field interview, the officer must be able to cite specific facts that support a belief that criminal activity is present, but it is not necessary to identify a specific crime believed to be in progress. To make an arrest, the officer must believe that there is more probable than not the suspect committed a specific crime. The police can't stop people anytime they feel like it. An officer may stop someone based on reasonable suspicion, but not randomly on mere suspicion or based on a hunch. The officer must have specific facts that can be stated to justify detention, sometimes called articulable suspicion. And there's not a set time limit on temporary detentions. It has to be the amount of time to conduct a brief investigation. That pretty much talks about what Table 12-3 talked about on page 357. So let's look at slide 12. Terry versus Ohio. A police officer viewed several men acting nervous in front of a store. Officer McFadden had years of street experience and believed they were casing a store for a stick-up. McFadden stopped the three men, patted them down, and found weapons. The court found that such stops, called Terry stops, with pat-downs for weapons was constitutional, as long as it was not intrusive. So Terry versus Ohio is the case that allows officers to do frisks, otherwise known as pat-downs for weapons. Page 359, if you look at figure 12-1, there's a diagram on Terry stops that is applicable to persons and vehicles where an officer is concerned about there being a weapon or suspects that there's a weapon and does a pat-down or a frisk. Let's look at slide 14. Standard for temporary detention continued. Temporary detention, there's no set time limit as discussed, but brief, minutes, not hours. Searches are limited to pat-downs for weapons, which is a frisk, a Terry stop, can't be used, and they can't use the evidence discovered to justify a search. Look at the top of page 360 of your textbook. When police acting on reasonable suspicion retrieve what they believe is a weapon, it is a legal search. If, in fact, the object they seize is not a weapon, whatever they seize will be admissible. This falls under the plain view doctrine. The right to retrieve items in plain view was from Minnesota versus Dickerson. Court allowed officers to remove items that did not feel like weapons if, by their distinctive feel, it could be determined that the items were contraband, and this is called plain feel. Slide 15, standard for temporary detention, continued. Special situations may request identification from a suspect. Car stops are more limited, which are discussed more in Chapter 13. Fingerprints cannot compel unless a suspect is under arrest. There are recent case law that allows fingerprinting at a crime scene. Interrogations, no need to Mirandize somebody if they're not arrested. Standards for temporary detention, slide 16, school searches. Students have fewer rights to privacy than the general public. Searches by school staff have fewer restrictions than the police have. Special needs of schools to maintain safe environment and loco parentis rights give school and school authorities more power. Searches must be based on reasonable suspicion that contraband is concealed, however. Canine searches, Brief detentions for sniffing is not an arrest and can not hold for a prolonged period. Luggage may not be opened prior to a canine search. Slide 17, arrests. Arrests are seizures and must have probable cause. It has to be beyond a mere suspicion, needs to show probable cause for each element of the crime. And probable cause is not needed for an arrest warrant, or if an officer is acting on the direction of another officer. Let's look a little bit more at probable cause to arrest on page 365 of your textbook, because this is really important. Probable cause to arrest. Probable cause, page 365, consists of a group of facts that makes a reasonable person more certain than not that an event occurred, that the person arrested committed a specific crime. This requires a high level of certainty than the reasonable suspicion needed for a field interview. Probable cause for each element of the crime is needed. At the bottom of that whole paragraph, proof beyond a reasonable doubt that is required to convict someone of a crime is a much higher standard than probable cause for a legal arrest. So you have these different varied levels. You have reasonable suspicion for a field interview, police stopping, detaining someone, talking to them. You have probable cause to arrest someone, which is reasonable that they committed the crime. And then you have proof beyond a reasonable doubt for the jury to convict someone of that crime. All right. Still on slide 17 at the bottom, after the arrest, if police question a suspect, then they must Mirandize the suspect. Let's talk about Miranda. Slide 18. It was Miranda versus Arizona. Miranda was arrested and brought into police custody. The police did not inform Miranda that he could refuse to talk or that he could request an attorney, even if he couldn't pay for one. The Supreme Court ruled that suspects after arrest who are undergoing questioning must be made aware of their basic constitutional rights as the following: right to remain silent, right to an attorney, and right to have an attorney at the state's expense if they can't afford one. Slide 20, powers to arrest. The police need probable cause to arrest for felonies if done without a warrant. For misdemeanors, they need a warrant, or the crime must have been committed in the presence of the officer. Or citizens, some states allow citizens to make an arrest for misdemeanors. A warrant allows an arrest in any situation. Warrants are always preferred for home arrests. Let's look at page 366 and 367, starting with 366. Okay. Let's see here. At the top of page 366, when the crime has occurred before the officer arrived at the scene, the arrest may be made by someone who witnessed it. That's a citizen's arrest. Second paragraph. For felonies, a citizen's arrest can be made by a person who knows of the existence of the crime, even though he or she did not observe it occurring. So it's different for felonies. Many states give the person making a citizen's arrest immunity from being sued for making the arrest only if the person making the arrest was correct in assessing the facts. A police officer can make an arrest based on probable cause, but a person who is not a police officer must be 100% certain that the crime occurred. I think it's the third paragraph. Misdemeanors. The victim or the police can then go to the prosecutor for misdemeanors. This is commonly referred to as swearing out a complaint. A judge will review the affidavit and, if probable cause has been established, issue an arrest warrant. That's for misdemeanors. Second to the last paragraph on page 366, officers are required to obtain a warrant if the arrest is to be made in a home. A search warrant is needed if the officers must enter any other home to make an arrest. The foundation for this rule is the right of people to privacy in their homes. And officers may enter a home without a warrant if there is imminent threat of violence to the occupant.